What you need to know about an ERISA Disability Approval letter that tells you you're only going to be paid for 2 years because your medical diagnosis is based on your subjective complaints. Well, congratulations. You've gotten a letter from the carrier or plan saying, hey, they're going to pay you your benefits. But in the body of this approval letter, they've said, your medical condition is based on subjective complaints. You've got fibromyalgia, you've got ME/CFS, you may even have migraines, and that's going to fall within our subjective medical condition limitation, and we're only going to pay you benefits for 2 years. Well, the good news is they're paying you, and I guess the good news is that they put you on notice that they're going to terminate your benefits, but obviously this is bad news. Now, my strong suggestion is that this is the time in which you need to hire an ERISA disability attorney, not just a couple months or days before they announce they're going to, in fact, deny your benefits and you get that denial letter. Why? Because you want to use this time to develop the necessary medical information in your file that is going to address this issue. The first thing you need to do, obviously, is to get out the disability policy or plan and learn what the definition is of subjective medical conditions and whether or not your condition, in fact, is one of the listed conditions. So let me give you an example. Let's say you've had back surgery and you're still having pain, but without objective findings on MRI or EMG or even physical examination that will explain your continued pain. Now, the tactics the disability carrier is going to use depends on the terms of the policy. And the policy may say you have to have objective evidence of ongoing disability. And it can't be just based on your complaints of pain, muscle spasm, or other subjective complaints. Now, we know that about 18 months, if not sooner, before the subjective medical condition limitation applies, they are going to start looking at how they are going to apply that. And the first thing they're going to do is look at your medical records. Your medical records need to document your objective findings on physical examination and diagnostic studies because without those sorts of things, they are probably going to apply the subjective medical condition limitation. So you want to make sure that your doctor is cognizant of this and is doing a bang-up job in your physical examination, documenting the findings. Now, you also need to make sure that if you have other disabling medical conditions, that those are well developed, because the disability carrier may say, well, I'm not going to pay your benefits anymore because of your back condition, but you might have diabetes or some other medical condition that is in fact causing or contributing to your disability. And again, you've got to be looking at the policy or plan to see what's listed, to see whether or not those other disabling conditions are also limited by the subjective medical condition limitation. You can see that this can be pretty complicated, and it's helpful, I think, for you when you get that letter saying we're going to pay but benefits are limited to just 2 years, that you start exploring hiring an experienced ERISA disability attorney, because that attorney will be reading the policy terms, looking at your medical records, and help develop a strategy that can be implemented now, not 24 months from now, that will attempt to successfully prevent or rebut a carrier's or plan's attempt to apply the subjective medical condition limitation. So don't wait till the last minute. Call me today at 727-894-3188 for a complimentary consultation.